Hi everyone, this is Adam Francoeur from the WOLFSDORF Immigration Law Group. Welcome to this afternoon's presentation. Myself and my colleague Joseph Shepard are going to be presenting a little bit of information regarding same-sex immigration that we've entitled Getting Them In When They're Out, which is our cheeky attempt at a pun. And we're going to be covering several options following the Supreme Court's decision in DOMA. For those of you who have followed our webinars, we've done some presentations on options for LGBT people prior to the Supreme Court's decision in the Windsor case particularly. This presentation is really going to track what's going on following the Supreme Court's decision in DOMA in the Windsor case, and a lot about immigrant visa processing, the nuts and bolts of immigrant visa processing, and the adjustment of status process. And so we're going to guide you through that in a cursory fashion. We'll have some time at the end for questions if you want to stick around for that. Otherwise, our emails are also at the end of the presentation, and you can feel free to email us individually. Joseph, did you want to add anything before we get going?
No, thank you very much, Adam, for leading us off. And we're excited about this change in the law and the new opportunities that are present for individuals in same-sex relationships, married, engaged, or otherwise. So, you know, I hope you enjoy this presentation, and Adam will start us off.
Great. Away we go. Maybe.
Maybe.
Joseph, can you move us forward?
I'm going to.
Thanks. Okay, so just as a preliminary qualification, you have to be married to a U.S. citizen or a lawful permanent resident to obtain immigration benefits as a foreign national who is in the United States. We're going to basically cover what marriage recognition looks like under federal immigration law, and again, this is post the Windsor case where the Supreme Court determined that the Defense of Marriage Act was a violation of equal protection law. So essentially, marriage recognition under federal immigration is sort of a three-pronged test. The marriage needs to be valid where it was performed, and you know we'll go into that a little bit, but it's the place of celebration where the marriage is performed. So if a couple is residing or domiciled in, say, Alabama, and they're married in New York, or they're married in now any of the U.S. states, say Minnesota, then the marriage would be lawfully recognized if marriage is valid where that ceremony was performed or celebrated in this case. So valid where performed, that's what that means. No bad faith, and that's bad faith regarding immigration intent. And we'll get into that a little bit, and then not contrary to public policy in the state where the individuals reside. And this one is a little bit tricky, but essentially there's a lot of good case law on our side on this one, and so we believe that this is not going to be a problem in the immigration law, and if as long as you're married in a place where the marriage is as long as the marriage is valid where celebrated, that there's not going to be any adverse public policy consequences. So it's not going to be a problem for immigration law. But this is the recognized three-pronged test under U.S. federal immigration law. So we do feel we want to explain it to you. Okay, great. Looks like I have control again. So, and just as a contrast, or in this case, a non-contrast, this is a slide about same-sex marriage in the immigration context. And this is the big deal. This is the big to-do. This is why we're so excited, because it's exactly the same for same-sex couples for the first time ever as it is for opposite-sex couples. So the three bullet points are the same. There is absolutely no special treatment for same-sex couples, and certainly there is no discriminatory or adverse treatment that that we've been seeing. The Department of Homeland Security has been very good about getting out in front of this issue and issuing positive statements about recognition. We've also seen the Department of State follow suit, so we feel very confident. We ourselves are going forward with many of these cases. We haven't gotten to the interview stage yet because June 28th was the first day that the DOMA decision was rendered, and so it takes a while for these cases to process, as you'll see as we go along. But we have a number of cases that have been receipted in, which is a wonderful thing, a wonderful sign, and we're going to cover some of the law behind it. But essentially, what you need to know is that the policy for opposite-sex individuals is now the same as the policy for same-sex individuals, with some minor tweaks. This is the slide that illustrates that. So it's the same. Just a note for any transgender individuals and clients out there, in terms of gender assignment or gender markers, SRS or sexual reassignment surgery is not required under U.S. federal immigration law. So you should certainly talk to one of us if you're concerned about that, or if you have any questions about SRS and gender markers on immigration documents or other documents that you'll need to present in order to prepare these petitions that we're talking about. But just as a general rule, please know that SRS is not required for immigration purposes. Okay, and I'm going to let my colleague Joseph take over here, but essentially we've laid out for you in the slide the places where same-sex marriages are currently validly being performed, and with a little exclamation point for England and Wales, who will soon be joining the club as of 2014. Joseph, do you want to take over at this point? Are you there? I guess he's not there. The list is pretty self-explanatory.
Adam, can you hear me?
Yeah, I can hear you.
Oh, sorry about that. I had a microphone issue. We can go forward with this. So there's 15 countries right now that are performing same-sex marriages, and these places, if the marriage takes place there and it's valid under the laws there, then it meets step 1 in this process. We have 13 states currently performing same-sex marriages, and 2 North American capital districts, Mexico City and the District of Columbia here in the U.S. Why we provide this information, this specifically, is important to consider for individuals who are either living in or last resided in a country in one of the 76 countries where same-sex relationships are actually criminalized, so the opposite of the spectrum. These 15 countries are countries where individuals can get married regardless of the gender of the 2 individuals. And these states are, if you're coming to the U.S. to get married pursuant to a K-1 fiancé visa, these are the states where you can get married. There's a link on the bottom of the page that takes you to Immigration Equality's website that has a great resource page for each country. And it breaks down frequently asked questions about each country and the last available laws for residency requirements for getting married there. But regardless of how to get married there, that's outside of our purview. What we are interested in is consular processing and potentially local I-130 filing, which we'll get into later in the presentation. But just for your reference, here are the 15 countries, here are the 13 states, and here are the 2 capital districts. And if you want more information about these individual countries, you can click on the link below. So the second prong of the test, no bad faith, as Adam mentioned, not fraudulent, not entered into solely for the benefit of immigration. And there are some special considerations for individuals to show that it's not fraudulent. Inclusive of that, besides individuals who identify as bisexual, there may be some instances where people are in non-immigrant statuses or have been in the U.S. in various non-immigrant statuses, potentially as a means by which to stay in the U.S. with their partner as a secondary means if they're still getting a master's degree or a PhD or potentially on an H-1B or another type of work visa. individuals, say, who have been students or students for 10 years or 20 years or 30 years and now are applying for this, and they've never shown this relationship in the past, there may be some instances of, well, is this a real relationship? So that's one of the considerations for good faith versus bad faith. Then finally,
for 1 second.
Yeah.
Great, thanks. I've been getting this question a lot, and just to clarify on point 2, not entered into solely for immigration benefits, we've been seeing sort of two situations with same-sex individuals who have been married. One, those who are married prior to the Supreme Court's DOMA decision in Windsor, and those who have been married post-Windsor. So for those who have been married pre-Windsor, and again, this is June 28, 2013, mark it in your calendars, it's really not at all an issue, this second prong. And I think it's really great evidence that you've not been married for the purposes of immigration benefits if you were married prior to that immigration benefit even being provided. For those who have been married after the Windsor decision when the immigration benefit has been available, the question often arises, well, we got married because we're in love and we want to be together, but we may not have gotten married, otherwise, or we may not have gotten married right away, except that for this immigration benefit. And I just wanted to clarify that word solely being very important, because what the Immigration Service is looking for is that the primary purpose of the marriage was not for immigration purposes. So if the primary purpose of the marriage was because you're in love, and the primary purpose was because you want to share your life together, then there's absolutely no problem under the U.S. immigration law. If the primary purpose was simply to get immigration benefits and you would not have been married otherwise, that may become a problem, but for most of you, that's not going to be the case. Certainly, you'd want to discuss that with one of us further if you think that might be a problem for you. But just because you were married after the Windsor decision and with the thought of the immigration benefit in mind doesn't mean that you're running afoul of this of this second tier, of this second prong, not entered into solely for immigration benefits. So I just wanted to add a quick note to that because I've gotten that question a lot from clients. Go ahead now, Joseph. Thanks.
Wonderful. The third prong here, not contrary to public policy in a state where the couple is domiciled or intends to domicile, where they intend to make their home. Now, before DOMA fell, there was some issue and disagreement among reasonable people of whether or not state mini-DOMAs or state constitutional amendments banning recognition of same-sex marriages or issuances of same-sex marriages would be strong enough public policy for this third prong to cause a I-130 petition for your spouse to be denied. And there were some evidence showing that as a matter of policy, or as at least in a practical matter, marriages between individuals where one spouse is transgender were still being, or rather the I-130 for those marriages, were still being approved even in states where there was contrary law in place banning recognition of or not allowing people to marry an individual of the opposite gender post-transition. So we saw ahead of time that there was an indication this was going to be the policy, and now we have confirmation post-DOMA. Now that the decision has come down from the Supreme Court, the executive agencies have followed suit and issued guidance, including DHS, USCIS, and ICE within their DOS and the DOJ. Everyone has said they will treat marriages the same, opposite sex, same sex. It doesn't matter for purposes of federal immigration law. So this is in the immigration context only. There is some, there are other areas of the law where there's still some gray area confusion and need to have things sorted out. But for federal immigration purposes, we know for certainty, at least under this administration, that these state laws and state constitutional amendments banning same-sex marriage will not be strong enough public policy on their own to warrant a denial. Examples of public policy considerations that would be enough in that state would be if the marriage, regardless of same-sex or opposite, was, say, to an immediate relative, brother or sister, if it was criminalized in that state, or first cousin if it was criminalized in that state. The things that amount to criminalized forms of marriage are strong enough. Maybe there might be some other forms of marriage taken into consideration with other factors that might be strong enough public policy, but we haven't seen any indication that there are some state laws banning recognition of same-sex marriage that would be enough to warrant the denial. So we have, in following this slide, various categories of the new options because DOMA is gone. In the non-immigrant visa context, in the immigrant or green card application process, and then the waivers that might be available to individuals who are otherwise inadmissible or need to clear up some question of admissibility beforehand, and then finally a brief discussion of the asylum procedures. So, Adam, do you want to talk about non-immigrant visas, or would you like me to keep going?
Yeah, sure, I don't mind. So non-immigrant visa is simply a way of describing visas that are temporary in nature and that are not permanent. When the individual enters the United States, their intent upon entry cannot be to permanently reside in the United States. So we've listed some sort of common types of non-immigrant visas. Many of you will be familiar with the Visa Waiver Program, which is carried out with a list of countries that the United States has a treaty with. You do not need a visa to enter the U.S. under the Visa Waiver Program. It's also known as ESTA, the ESTA program. You're permitted to enter the United States under the ESTA program or the Visa Waiver Program for a period of up to 90 days. It's very super important that if you do enter the United States under the Visa Waiver Program, that you leave the United States within that 90-day period, or you're going to lose that privilege, and nobody wants that. So just make sure if you are a Visa Waiver Program person, you do leave within the 90-day period. You may also be eligible to adjust status if you're a foreign national spouse to a U.S. citizen, which we'll cover a little bit later. But the Visa Waiver Program, please know about the 90-day limitation. Single intent visas, and I put in parentheses after that primary intent because the single intent visa is a little bit of a misnomer. You may actually, for example, you may enter on a B visa and attend like a yoga class or some other sort of, class that's like non-certification class, or visiting legal classes or things like that. But your primary purpose, your primary intent for entry under the single intent visa should govern which visa you enter the United States under. So a B visa is a visitor's visa. If you came to visit, but you're looking at schools, for example, and you wanted to come and check schools out, people say, should I enter under an F visa or a B visa? And since your primary purpose is touristic, you can enter under a B visa and still look at that school, but look to the primary intent of your purpose for visiting the United States. And then there are dual intent visas. We often call these also hybrid visas. And they're primarily work-related visas. The examples are the H-1B visa, which is a specialty occupation visa, and the L visa, which is for multinational executives and managers, and people with specialized knowledge. And those visas allow you to have dual intent, so they allow you to enter with non-immigrant intent, but also to have an expressed immigrant intent. And by immigrant intent, I mean a declared intent to file a green card petition. So that's the difference between a non-immigrant visa, which is temporary in nature, and an immigrant visa, also commonly known as a green card. And a dual intent visa allows you to sort of have both of those intents simultaneously upon entry. And one thing I always like to point out with non-immigrant visas regarding intent is that the intent is a snapshot intent. The intent is assessed at the time of entry. There's a window of period, it's 30 days and 60 days, where you should, maintain that primary intent. But what we are talking about intent, we are talking about a snapshot intent. and there's a little note here that you must not violate non-immigrant status, and that's always important when talking about visas, particularly the non-immigrant visas, the single intent non-immigrant visas. You can't express a non-immigrant, you can't express an immigrant intent with a recent non-immigrant entry. So you want to be pretty careful about that if you have a non-immigrant visa and you're thinking about adjusting status. All right, we're moving forward here. And so other non-immigrant visa options, just to cover what it looks like for dual foreign national couples. So for dual foreign national couples that are married, there are options, there are derivative options. And so for a student visa, that's the F1 or the M1, the derivative spouse would get the -2 version of that visa, so it's F2 or M2. The derivative spouse of an H1B gets an L4, an H4, and the derivative spouse of an L1 gets an L2. The important thing to keep in mind here is that some of these permit work authorization and some of them don't. For example, the H4 does not, the L2 does. So if you are a foreign national, if you're a dual foreign national couple, and there's an individual who has the primary visa and then the derivative visa, it's important often for the derivative spouse to be able to work. So you should be aware that different visas have different work eligibility attached to them for derivative foreign national spouses. If you're not married, there are options yet. The primary one is the B2 cohabitating partner visa. And this was negotiated with the Department of State essentially for foreign diplomats prior, when DOMA was in place as an end around to the inability to get like an H4 or an L2, and particularly the A and G spousal exceptions was also included in this package deal. But essentially it's an end around to the previous inability to get a derivative visa for a same-sex partner. You can get a 1-year validity period for the B entry, and it's extendable in 6-month increments, whereas typically that 1-year initial entry is a little bit hard to get under the B. It's typically a 6-month period, so it's an option. It's probably not, for a lot of people, it might not be the best option anymore, since derivative spousal visas are, same-sex spouse visas are now options. But it is maintained in the Foreign Affairs Manual as a valid way to enter if you're not married. So we kind of put it in here just to notify you about it. And then, of course, each person may qualify independently for their own visa, neither under the derivative nor the cohabitating partner categories. And you just have to make sure that you maintain eligibility for the visa category that you're in when you apply for the visa and for the duration of the visa. For example, you can't enter under a visa that's tied to a specific employer, change employers, not do a change of employer petition, and presume that you've maintained your non-immigrant status. That's not allowed. Okay, so just breezing through that, I'm going to move on to immigrant visa options. And I'm going to let Joseph, do you want to take over at this point?
Absolutely. Thanks, Adam. Make sure you can hear me first.
Yep.
Great. All right. So immigrant visa options. This is going to cover foreign nationals who are married or engaged to a U.S. citizen regardless of where they are. This is a broad overview of the different options. If they're married in the U.S. or outside of the U.S., if they're not eligible to adjust status, or they choose not to adjust status for some reason, or they're outside of the U.S. and start the process from there, then the appropriate ways to go are an I-130 petition, which is the petition to classify your spouse as an immediate relative. And then upon approval, you can immigrant visa process, which is IVP for short. And I kind of put in the general time frames for these just to show people, that it's about a 10-month minimum process, and you'll be outside during that process for the whole period. I put a star there for some exceptions for local filing of I-130s, either with the local USCIS international office, if there is one in that country, and also if there's any exceptional circumstances that would allow you to file with the Department of State consular office in that country. I'll go over that in a minute. If you are abroad and are in the country where you married your U.S. citizen spouse, you can do an I-130, and then as soon as you get the receipt notice, add a K-3, which is a similar type of visa to the K-1, and I'll go over that in detail in a minute. And then upon approval of the K-3 and K-3 visa processing, you can adjust status from within the U.S. Again, that's about an 8 to 10 month period when you're waiting outside of the U.S. And then from start to finish, even after you're in, might be up to over a year. Same with the K-1, which is the fiancé visa. As soon as that's approved and you K-1 visa process abroad, then you may enter the U.S., get married, and adjust. If you start this process from within the U.S., if you're in the U.S. on a non-immigrant visa and you're married to a U.S. citizen, and or you are in the U.S. and you've been even potentially out of status because of the immediate relative category is one of the exceptions where if you're not maintaining an underlying non-immigrant status, that may be forgiven as a matter of discretion during the process, assuming all else equal and there's nothing else in your file that would otherwise warrant a denial. That process right now is about 5 months, and based on the sheer number of applications that have been filed by our office, let alone everywhere else, including all the individuals who are now eligible because DOMA has been struck down, we expect that this will creep up to about 7 months. But right now we're still seeing, at least in the LA area, Adam, I don't know if it's the same for New York, but we're seeing about a 5-month minimum from date of filing to date of interview and green card issuance.
Yeah, it's a little bit longer here in New York. We're sort of seeing 6 to 8 months. This, again, is with our non-same-sex petitions because we haven't taken a same-sex petition from start to finish yet. But they are moving quicker than previously, so that's a positive sign. And what's nice, too, is that the fingerprinting notices and all of that stuff are moving ahead very quickly. So that's encouraging.
And so just as a little bit of anecdotal addition here, for cases that were filed right around the DOMA decision that were, for opposite-sex couples, we are seeing interviews being scheduled in September and here in California. So we expect the first round of interviews for California for our filings for same-sex couples to be starting in and around October and then going into the months thereafter.
Yep, we don't have any interview notices yet, so you're ahead of us.
All right, so let's start with immigrant visa options and get down into it and go through with a little bit more detail about what's involved. The first step in any process, be it through adjustment of status or through immigrant visa processing, will require the I-130 petition. And this is filed by the U.S. citizen spouse. If they are in the U.S., they file it with USCIS in the U.S. And if they are out of the U.S., then they file it, it depends on where they are. So if you're in a country that has a USCIS international office, and I provide a link there that provides the USCIS international offices, then you can file in that country as long as you can show that that's where you're going to be for the time period. Otherwise, you also can file with USCIS in the U.S. Of the 15 countries that have marriage equality right now, or at least will soon, we have South Africa actually has a USCIS international office in it in Johannesburg. For individuals who are married in Mexico City, there is a USCIS international office in Ciudad Juarez. There's also a Mexico City office and a Monterey office. And then, with England and Wales in 2014, which is very exciting, coming into the mix, USCIS International has an office in London. So individuals, U.S. citizen petitioners who are living abroad with their partner or spouse because they are separated or excuse me, because they're living in exile because of DOMA, or they just happen to be living abroad temporarily, will be able to process the I-130 at that USCIS international office there. The processing of an I-130 at one of those international offices can shorten the period of time dramatically. Right now, at least based on our recent cases, opposite sex, because we haven't had start to finish finished, but in Mexico City, the I-130's processing times are around 90 days. In Johannesburg, they're about 45 days. And in London, they're about 1 month. So that can be much faster than the 4 to 5 month process or 5 to 6 month process with USCIS in the U.S. Just a consideration, something to think about. Talk with an immigration attorney who knows about filing I-130s locally. Don't try to do it on your own, or you can just make sure that you do your research very carefully. But I would recommend speaking with a professional about it. If your country where you're living either in exile or temporarily for whatever reason does not have a USCIS international office in it, then the rules say you have to file with USCIS in the U.S. There is an exception, and there are some exceptions. There's a very limited list of examples of exceptions that can apply to being able to file directly with your embassy or consulate in that country, which is Department of State, not USCIS. And if you submit a request for an exception, the consulates will have to clear it with the USCIS International Office in their area to make sure it's okay first. So that's why attorneys, we typically draft these type of requests and then submit them to the embassy with the understanding that it'll be eventually reviewed and decided by USCIS. So it's written in a careful way. So that's generally the I-130 process. The second step in this case, if you're doing immigrant visa processing abroad and your I-130 is pending a very long time, or your I-130 is at least filed, you have the option to, once you get the receipt notice for the I-130, also file a K-3 petition in the U.S. The K-3 is for individuals who are foreign national spouses of U.S. citizens who have a pending I-130 for them. This would allow them to to come into the U.S. during the time that the I-130 is pending and await the decision from within the U.S. Upon approval of the I-130, then, they could adjust status instead of immigrant visa processing. In theory, whenever this was passed by Congress or brought into existence, the I-130s were taking much longer, and K-3s were a means by which people could circumvent waiting outside for a year and a half of being separated from their spouse. But now in practice, the processing times for K-3s take longer than the I-130s, so they're rarely, if ever, approved before the I-130, making them pretty much not that helpful. Another caveat with the K-3, you can only apply and do K-3 visa processing at a post in the country where you got married. So for same-sex marriages, if you were married in one of those 15 countries that allow it, whichever country you were married in, you could only do the K-3 visa processing there. If you were married in the U.S. and were doing immigrant visa processing abroad, the K-3 would not be an option. So let's say that the K-3 never happened or the I-130 was approved before the K-3. That brings us to step 2, immigrant visa processing. USCIS will, assuming that it's from USCIS in the U.S., will send the I-130 approval directly to the Department of State's National Visa Center. The National Visa Center is the U.S.-based arm of the Department of State's consular apparatus that does the initial screening and review of all civil documents and what we used to refer to as Packet 3. Individuals who are processing through the NVC will have to send original documents up to them upon review and completion of all of those documents, including things like birth certificates, marriage certificates. If there are any 864 complicated issues in there, all those original documents along with the 864, and the immigrant visa fees. Once that's approved, once that's pre-screened and green-lighted, then they send the original package directly to the consular post abroad, where you'll be doing your immigrant visa processing. So it's very important on the I-130 to indicate where you're going to be doing the immigrant visa processing. That's why it's imperative ahead of time to strategize this. There's different ways and different jurisdictions where you can or cannot do immigrant visa processing, and there's also the consideration of making sure the National Visa Center knows and follows what you ask them to do and send the package to the correct post. It's also a little side note here with the 601A, only in certain situations, note on the screen. The 601A is a provisional waiver of the 3 or 10-year bar. So some individuals who may be subject to a 3 or 10-year bar to re-entry to the U.S. because they accrued some amount of unlawful presence in the U.S. and then subsequently departed, or they're in the U.S. and they're doing immigrant visa processing abroad for whatever reason, if they entered without inspection or they just choose to do it. But if they left the U.S. to go do the immigrant visa processing, they would trigger this bar. So you can actually apply ahead of time before you depart the U.S. And as a matter of fact, you have to be in the U.S. to file this, and it's filed while the NVC is processing the immigrant visa fee. As soon as you pay the immigrant visa fee, then you take the receipt and you can file the waiver. I'll get into the waivers later, but just be aware of that's the only situation where the 601A comes into play. At the specific consular post, that's what we would use to refer to as Packet 4. We would submit all of the visa application forms and documents. The paper forms are referred to as, this is a little bit in the weeds, and sorry to get into it so much, immigration nerd alert, but the forms for some posts are DS 230 parts 1 and 2, and I list this because I think it's interesting that there are a few posts now that are using the DS 260, which is an online application similar to the DS 160 for non-immigrant visas that individuals complete and submit electronically. The DS 260 is only available at some posts, and these posts are kind of doing a pilot test run of this, but if there is the DS 260 online, the chances are that that post is also doing electronic review of documents with NVC or without, where instead of sending the originals, you actually scan and upload and send the PDF copies of them. If you have any questions about the DS-260 or are encountering an immigrant visa processing issue with electronic case review instead of original document review, contact an immigration attorney who knows about these issues. When I talk about jurisdiction for immigrant visa processing, I want to differentiate the differences. The rules say that you have to immigrant visa process in the country, at the post, in the country where you last lived or resided before going to the U.S. That's the general rule. There is, of course, like any rule, an exception, and it's the physical presence exception. If you're in an area but have no residence there, you can make your application there if the consul approves it and gives you that ability, if you can show that you will be able to remain in that area for the period of time required to process the visa. So that's an important consideration ahead of time before filing the I-130, is to seek pre-approval. Say if you are going to be working for 6 months, say, or 8 months in Sweden, or you're going to be in France, you would be able to potentially process there as long as you had the appropriate visas in place and could show that ahead of time and get pre-approval. The other exception to that is its whole other category, which is the third country processing. It's for individuals who are not a resident of that country and also not physically present in that country, may be able to, in some instances, process their immigrant visas in that post. This is what comes. This is important for individuals, like I mentioned earlier, who are living in one of the 76 countries in the world that criminalize same-sex relationships, and or fear persecution in their home country and are seeking another post in which they can process. Because sometimes, even though things are supposed to be confidential and are generally kept confidential, they may feel uncomfortable processing the visa where there may be people from their town or community who work in the embassy or consulate in their home country, and fear being outed, for lack of a better term, for sponsoring, or rather going through immigrant visa processing based on marriage or engagement to a U.S. citizen. So you can request discretionary jurisdiction from third country posts. Again, that's why I say it's important for attorneys to be involved in contacting these posts ahead of time, be it for the exceptional local processing of an I-130 or discretionary approval of third country processing, or rather safe third country processing for individuals. There's also one last small category of the homeless jurisdiction, and that is individuals from certain countries that don't have U.S. consular services must process through designated countries. For example, individuals from Iran or Libya or Somalia have designated posts. For example, in Iran, I believe one of the posts is Frankfurt, another is, I think, Rome, and another maybe in Turkey. Either way, there's designated posts for certain countries. There is not, at current, a designated post for safe third country national processing of immigrant visas for LGBT individuals or same-sex couple immigrations. So, that being said, you must carefully consider and make a request for discretionary relief and local, or rather safe third country processing. Then we also have, like I made reference to, the K-1 fiancé visa for individuals who intend to marry a U.S. citizen in the U.S., obviously in one of the states that allow it. And again, just like the domicile rule for marriage recognition, it's the state where you reside or intend to reside is not the controlling factor. The controlling factor is where the marriage will be valid. So in a opposite sex couple K-1 case where practitioners would instruct the couples to provide evidence that they intend to marry in the U.S., I would say practitioners should be more cautious with same-sex couple K-1 visas and clarify and have the couple clarify exactly where they intend to get married. Because if they intend to get married in Oklahoma, that's not going to work out so well. But the K-1 petition right now is about 5 months processing, and K-1 visa processing in itself takes roughly another 5 months. You come to the U.S. with the single entry K visa. You get married within 90 days. Yay. You are eligible to apply for work authorization upon entry into the U.S., but whenever you apply for adjustment, you are eligible to apply for work authorization as well. That's typically when people do it because they're not trying to work. Whenever they come in, they're trying to get married. Nonetheless, speak with an attorney if you have questions about that. And finally, adjustment of status. Adam, I will turn this over to you.
Okay, great. Thanks. So this is just an update. This is a slide that references the process from within the United States. So the process that Joseph was just describing was when the foreign national, or both the U.S. citizen and foreign national, are outside of the United States. This process, called adjustment of status, which refers to the adjustment of status from non-immigrant visa or non-immigrant visa status to that of immigrant status or immigrant visa status from within the United States. So these are preliminary, well, the preliminary eligibility requirements are one that you have to be married to a U.S. citizen spouse or a lawful permanent resident spouse, which is a fancy way to say somebody who has a green card. And this is the key one here with the asterisk, that you must have entered with inspection. So this one is really important. Entering with inspection typically means that you entered on the visa. You can also enter with inspection under the visa waiver program, or if you're a Canadian, you won't need a visa, so you can enter with inspection without a visa. But for the majority of people who aren't entering on the visa waiver program or who are not Canadian, this means that you enter the United States with a visa. You will also need to provide evidence that you entered with inspection. Typically, that's done with a date stamp in your passport and or with an I-94 card. The I-94 is the entry record that the Customs and Border Patrol issues upon each person's arrival inside the United States. They have recently, this is CBP, has recently moved to an electronic I-94. For those of you who have traveled prior to 6 months ago and entered the United States, you'll be familiar with the older oak tag style card that's a little sort of white square that goes in your passport, is typically stapled in, has, you know, a very kind of typewritten set of numbers up at the top, your class of admission, which is the type of visa that you entered under, and your name that you fill out, and you fill that out like on the airplane on the way to the United States. So that's your I-94 card. That record is now electronic. For those people who travel frequently inside and outside of the United States, now that that the CBP has moved to electronic records, just briefly, it's really important to maintain a record of that, because that record of entry vanishes once you leave the United States. So when you enter the United States, the first thing you should do when you get home, or the very next day, if you don't do it that same day, is to print out your I-94 card and keep a record of it somewhere that's permanent. You know, make a PDF, keep it in your files, keep a hard copy in your files. If you are working with a professional or working with us, make sure you send us a copy of that so we have it for our records, because again, it does sort of vanish from the electronic system upon departure from the United States. Also, we've been noticing that there are a lot of errors with the implementation of the new system. So certain people will have the wrong entry date or the wrong class of admission, and then they have to go down to, you know, to the CBP Office to Secondary Inspection and have that corrected. And the longer you wait to do that, the more of a problem it becomes. So I just wanted to stress the importance of entering with inspection, what that looks like now, and the necessary requirement to provide the evidence of that inspection. Also, you must not be inadmissible to the United States. Joseph covered some of the waivers to inadmissibilities. Some classic inadmissibilities to the United States are for criminal acts, which include, unfortunately, a wide array of activities that one might not think would render them inadmissible, and include overstaying and things of that nature. As long as you enter with inspection, you will be eligible for the adjustment process. So even if you entered, you know, 10, 12 years ago and you haven't maintained your status, you do remain eligible for adjustment of status so long as you entered with inspection and you're not otherwise inadmissible. You know, the key there is to enter with inspection. The inadmissibility is often triggered at the time of reentry, or in the case of applying for the green card, that application is considered an admission. So that's something you want to be careful about. But just be aware that those are the two primary, well, and having been married to a U.S. citizen or permanent resident are the primary eligibility requirements.
I would like to just jump in just for a second, too, because the next slide will go over specifically marriage to a permanent resident. I just want to emphasize there's a small difference with between the permanent residents and the U.S. citizens, and there may be more requirements for the permanent residents.
Thanks. Yes, this is an important distinction. So glad that we'll cover that shortly. Also know that if your marriage is younger than 2 years, you will have what's called conditional residency or conditional green card. You will need to apply via the application, the joint I-751, to have those conditions lifted. If the marriage does not survive that 2-year period, depending on your status and depending on, well, specifically depending on the U.S. immigration office that you're applying at, that can get a little tricky. Certainly, if you're in that situation and if your divorce is even going to be recognized, which is a major question right now under U.S. immigration law, U.S. law, if you're a same-sex couple, those will become very complicated issues. We won't really deal with those in detail now, but know that that's going to be a very complex procedure. And then, you are eligible to apply for citizenship within a 3-year period. So it's a pretty quick way to become a U.S. citizen, and it's pretty simple. Although perhaps it doesn't sound that way after this presentation.
That's awesome.
All right.
I can talk about the permanent resident side. It's very similar. In right now, the August and September Department of State visa bulletins have shown that the immigrant visa category for spouses and children of permanent residents is current for the first time, which means every year there's a cap on the number of visas for immigrants that are issued in each of these categories. Immediate relatives or spouses of U.S. citizens do not get a category. They're always available, so there's no cap on those. But there are caps on the other immigrant family-based categories, one of which is the F2A category, or rather second preference immigrant visas, and that is for spouses and children of permanent residents. The spouses of a permanent resident being current right now means that people can concurrently file if they're married to a U.S. permanent resident. They can concurrently file the I-130 with the adjustment of status. In addition to entering with inspection and otherwise being admissible, those individuals will have to demonstrate that they have some non-immigrant intent, must be able to establish they have a valid non-immigrant status whenever they file these. The visa bulletin published for September has indicated that they did this, bringing it current to increase demand for these types of visas, because while they had no shortage of applicants, they were unable to actually process them because of just cases languishing in warehouses or individuals not following up with their applications and terminating them. So they were not able to effectively get through the line. So they figured if they encouraged people to apply, at least my analysis of this is that they would increase demand for these visas overall and therefore speed up the process. While it certainly has had the effect, and there are lots of individuals in this category filing the I-130 and AOS at the same time, and that's the AOS is the adjustment of status again, this will likely retrogress coming in October or sooner, depending. Hopefully not sooner for individuals who have not yet filed, but it is possible. They could revise the visa bulletin during September if they see a marked increase in filings and have sufficient number. But it's very likely, at least, or rather almost certain, that October 1st they will stop the ability to concurrently file your adjustment in I-130. The reason that's important is because if the adjustment of status application is filed at the same time based on marriage to a U.S. permanent resident or green card holder, and it's accepted by USCIS for processing, as soon as they hit the number of visas that they're allowed to issue each year for each category, then that's immigrant visas, then even individuals who have their adjustment of status application filed will have to wait until a visa number becomes available. That could mean the next fiscal year. So there are even people who have filed, but have filed during the end or right before they retrogress this category, may see a delay in the adjudication of their applications. Luckily for individuals who filed adjustment of status applications during this window, are able to also file for employment authorization and advanced parole, assuming they're eligible for those things. And those are renewable annually while the adjustment of status application is pending. For those married to U.S. permanent residents who filed early enough, will have their adjustment of status applications adjudicated in the normal fashion. And if you have any questions about that, ask an immigration attorney. Because it can be pretty complex when you get down into the weeds. But like I said, retrogression is coming, and October 1st or sooner, this will no longer be an option, at least in the short term. The I-130 can still be filed at any time, but that does not necessarily mean, or rather, it does not mean that the individual will be able to start the IVP process or the AOS process until that number becomes current again. If the I-130 is filed today and, say, 2 years from now, that number becomes current, then they will be able to file their adjustment of status application, but they'll need to be and maintain some non-immigrant status in the U.S. until then, or depart the U.S. and wait outside for that number to become current. So just an important little side note there. For waivers, now I mentioned earlier about the 601A, which is the provisional unlawful presence waiver, being only available to individuals who are in the U.S. who are going to IVP, but would trigger the bar upon departure. I will continue the rest of this waivers, but Adam, I believe, I don't know if the New York office has been doing or seeing a lot of the reason to believe language in some of these denials, but we've seen a few, not in the same-sex marriage context. This was, cases have not gotten to that point yet that have been filed since June, but and this, by the way, the provisional waiver process has only been in existence since March, but individuals who are only barred from entering the U.S. and only have a bar based on the 3 or 10-year bar can, safely or conservatively process the 601A. USCIS is denying 601As even if there is a, quote, reason to believe that they're inadmissible for some other reason. So they might say that there's a reason to believe that you also had some kind of misrepresentation without even proving the misrepresentation. Whatever that reason to believe is doesn't matter because it's discretionary and they're denying them. That does not mean that all hope is lost because the individual can still depart the U.S., trigger the bar, and then at the immigrant visa interview during IVP, once the consular officer sees that there may be some reason to believe and or they apply for their 601 period without the A, for that waiver, they can wait outside and try again with the 601. So 601A, if you're in the U.S., 601 is a backup to that outside of the U.S., but a 601 can also be used if you are potentially eligible for adjustment of status and you're ineligible based on for some reason. For example, maybe you were admitted, but you were admitted incorrectly because it was officer error, and it turns out you, in fact, were subject to a 3 or 10-year bar, but you didn't know it, and the officer either didn't know it or missed it. Or fraud, misrep, plus a 3 or 10-year bar, or some other criminal grounds, which would require a waiver. Just an important distinction there is all I want to impart on this slide. Is the 601A is the provisional waiver process for individuals who are in the U.S. who are seeking to consular process and have an approved I-130. But if they departed, they would trigger that 3 or 10-year bar. Oh, and the important point about the 601 or 601A is, what's the standard? Well, you have to be able to demonstrate that the denial would otherwise result in an extreme hardship to your U.S. citizen spouse or U.S. citizen parent. Not U.S. citizen children, but any hardship suffered by the U.S. citizen children as it relates to and as it inflicts suffering or extreme hardship on the U.S. citizen spouse can be shown, but the qualifying relative here has to be the U.S. citizen spouse or parent for purposes of the waiver, be it 601 or 601A. A 212 waiver is permission to reapply. So for example, individuals who have been previously removed from the U.S., deported, excluded, etc., or otherwise have immigration violations on record, potentially failing to appear for a removal hearing in immigration court. And a 612 waiver for individuals who have been in the U.S. on a J1 and are subject to the 2-year home residency requirement for whatever reason, and now seek to adjust status. This is assuming that they're adjusting status based on marriage to a U.S. citizen, but they might need a J1 waiver for other reasons. Nonetheless, you file directly with USCIS if your basis for the waiver is exceptional hardship, which is different than extreme hardship, and or persecution, if you fear persecution in your country. And this is a much higher standard of fearing persecution than in the asylum context, and it has much more limited types of, types of classifications upon which you can claim fearing persecution for. For example, particular social group is not included in persecution for a 612 waiver of the 2-year home residency requirement. The other types of 612s that you do not file yourself with USCIS, but the Department of State does if they recommend the waiver and you apply with the Department of State, is because your country has no objection to the waiver and you process and obtain a letter from your embassy, your home country's embassy in the United States in Washington, D.C., saying they have no objection, or there's an interested government agency. Usually it's the government agency that provided the funding for your J1 program, which made you subject in the first place. And therein lies the question about government funded. And, the 612, if you are filing it on your own with USCIS or through a professional with CIS, the basis is our exceptional hardship or persecution, and the Department of State files and submits the 612 request if you apply to them first based on no objection, interested government agency, or the very other limited circumstances. All right, and so now for asylum, I'm going to turn it back to Adam.
And thanks for bearing with us, everyone. We're almost there, and we just wanted to briefly cover the issue of asylum because it does still come up a lot. It is still, there is still, worldwide persecution of LGBT people, and it remains a valid basis under which to come to the United States. Well, if you're in the United States, there's a physical presence requirement for asylum, so you have to be inside the United States. But it does remain a valid option for a lot of people, for a lot of LGBT people. Essentially, prior to getting into some of the particulars of it, I do want to caution people that it's not really a first choice option. It's really, it is supposed to be a tool for people who are suffering pretty severe forms of persecution. And the one thing you should know if you're applying for asylum in the United States or you're thinking about applying for asylum in the United States is that it imposes severe travel restrictions on you. And a lot of people are not aware of this up front when they apply for asylum. And so as a practitioner, as practitioners, our firm really likes to in some ways discourage asylum petitions because of these travel requirements. But primarily the one you should be aware of is that it places a severe travel restriction on your ability to return to your home country. Essentially, if you're applying for asylum, you're claiming that your home country is going to permanently harm you in some way that is so severe that you essentially fear for your life. That's not the legal standard, but that's essentially what you're saying. So the U.S. government takes a very strong position when they grant asylum that you are not to return to your home country. And in fact, if you come to the United States, return to your home country, come back to the United States, and then apply for asylum, that can be actually a barrier for obtaining asylum. So there are strong travel restrictions, and that travel restriction theoretically remains for your entire life, although certainly it remains at least until you become a green card holder or a U.S. citizen, depending on who you talk to. So there are severe travel restrictions if you have elderly parents or a sick relative. You won't be able to travel home, and it's something that you should really be cautious about if you're thinking about applying. That said, it is a positive tool for many LGBT people who are being persecuted in their home country on account of their sexual orientation. Asylum in the United States requires that you have suffered past persecution, which is harm rising to the level of persecution. Typically, that's physical or mental harm. There can be other types of harm that do render you eligible for asylum, although they're fairly difficult to prove. An example of that is like economic harm, although the standard is very high. Typically, we're talking about physical and mental harm, and even in that realm, we're talking about physical harm primarily. If you haven't suffered past persecution, you can apply for asylum based on what's known as a well-founded fear of future persecution, and that's that that there's a class of people who are being persecuted. In this case, it would be LGBT people or individuals who are HIV positive in some cases, or groups of people that are HIV positive, and that simply by virtue of your simply by virtue of your membership in that group of people, you have a legitimate or a well-founded fear of future persecution. There are 5 sort of bases to apply for asylum in the United States. It's race, religion, nationality, political opinion, and the final one that's listed there, a particular social group. This last one, PSG as it's called, is sort of a catch-all category. It's the category under which sexual orientation is included. To a certain extent, transgender and HIV positive individuals are also included in the particular social group, although the law is not as developed in those areas as it is for sexual orientation, which in the Toboso Alfonso case was designated particularly, was recognized as a particular social group, excuse me. This category has evolved since 1994. It's a very complex case to make currently, and it's very unclear whether sexual orientation would make it under the current law for a particular social group designation and recognition. But you should know that there is a precedential decision for sexual orientation, so it's per se particular social group under U.S. immigration law. The other big thing to know about asylum is that you have to apply for asylum within 1 year of your arrival to the United States. If you don't, and some practitioners will tell you that's 1 year of the expiration of your period of admission, and that is wrong. It's 1 year of your entry into the United States. Then you're barred from applying for asylum, and you're relegated to applying for withholding of removal and withholding under the Convention Against Torture, which are sort of lesser, for lack of a better word, forms of relief than our asylum, and they do not lead to a green card. Essentially, you do maintain a formal order of deportation in those cases, but then the government doesn't affect that deportation. You are eligible to work in the United States if you obtain withholding of removal or CAT, but you will not be allowed to travel outside of the United States. If you obtain asylum in the United States, you're eligible for work authorization immediately upon approval. You're eligible to apply for an advanced parole document to be able to travel outside of the United States, although again with the caveat not to your home country. And then you're eligible to apply for a green card following 1 year of the receipt of your approval of your asylum grant. And let's see. And we have here in red a big slide on immigration reform. For those of you who have been following the issue, you'll see that it's been quite an up and down battle. The Senate, has passed a version of the bill, and the House is now wrestling with the issue. The politics of it are anything but certain, but it does appear that the House is going forward with a piecemeal approach, which means they're not going with an omnibus approach like the Senate did. And they're going to go issue by issue, which means that that any path for comprehensive immigration reform is going to be long and arduous. For those of you unfamiliar with the broad strokes of the bill process, it does require, the same bill to be passed in the House and the Senate. If the House passes a bill and it doesn't match the Senate bill, then they have to be reconciled in conference. They have to be the exact same that are passed through both houses of Congress in order for the President to go forward and sign it and to enact it into law. And that looks difficult at this point. So there's a lot of hope out there. There's a lot of energy. And there's a lot of people doing great work, principally among them Immigration Equality. And disclaimer, many of you may have become aware of us through Immigration Equality. Joseph and I are both former employees of Immigration Equality, so we just do want to put that disclaimer out there. But there are a lot of great people doing work for comprehensive immigration reform. Certainly it's worthwhile, and we believe that all LGBT people should support immigration reform, even though the Defense of Marriage Act has sort of rendered one of the primary asks of the LGBT community to be somewhat mooted. There's still a lot of issues that affect the LGBT community that you should be aware about, including the DREAM Act, the incarceration and detention of LGBT people in immigration detention, and many other issues, including some of the issues that we covered with asylum. So we do encourage you to continue to support immigration reform. We're happy to provide updates if you want to know more about that. Also look to our blog for updates on this presentation, information regarding same-sex immigration, information regarding same-sex marriage as it relates to immigration, and updates to immigration reform movement. Thanks very much for bearing with us. I think that we made it just in over an hour, so that's pretty great. And I think we're going to move to take some questions now. So Joseph, can you?
Yeah, absolutely. We are unfortunately unable to do the questions at this time, but we ask that you email your questions if you have them directly to us, and we'll respond to you. We are just running out of our time. And before we go, wanted to say thank you very much for your time and your attention to this really important issue and this really pivotal period of LGBT history. In addition to what Adam said about supporting immigration reform, it is important. LGBT is not a mutually exclusive group or interest group, personal group, or any kind of group with other kinds of identity-based groups or other. We are a very multicultural designation, and we are from lots of places and of lots of different political leanings. Nonetheless, immigration reform is needed, and thank you very much for your time.